that central banks can take to protect against those types of claims. Lori and I both have an extensive amount of experience dealing in matters where we've represented both sovereigns and central banks in both international arbitration and litigation matters. And it's with that background that we approach this topic. In the investment treaty context, Lori and I have worked on several matters related to central banking activity and the banking sector generally. We represented Greece, the Hellenic Republic, in 3 arbitrations arising out of the 2012 financial crisis, including with respect to claims by certain Cypriot banks relating to emergency liquidity assistance from the Bank of Greece. We're currently advising the Bank of Spain in connection with an arbitration, again related to the provision of emergency liquidity assistance. We have represented Austria in arbitrations related to claims arising out of its banking sector as well. We also have extensive experience in litigation matters involving sovereigns. I represented Argentina for over a decade in all of the disputes that arose out of the restructuring of its debt following the 2001 financial crisis, including litigation in New York brought by creditors attempting to seize assets in the form of reserves of the central bank located in New York, and that claim was rejected. Today, our focus will be on central bank conduct during the financial crisis, related investment treaty risks, and practical risk mitigation strategies. Specifically, we will cover the following topics: investment treaty claims arising from financial crisis related measures, investment treaty standards that are relevant to those types of claims, defenses that may be raised in response to these types of claims, and then finally some steps that central banks can take to mitigate against the risk of investment treaty claims in this context. So in the first part of the presentation, we will provide an overview of central bank measures that may impact investments in the banking sector to give some context and to give some examples of the types of activities that may give rise to claims. And we'll highlight some recent examples of treaty claims that have been brought against investors related to these types of measures that have been taken by central banks during financial crises. There is a wide range of measures taken by central banks and other regulatory bodies that can adversely impact the investments of foreign investors in the banking sector. That's really what we're focused on and what can give rise to investment treaty claims. When a foreign investor has an investment in a particular jurisdiction and either a central bank or a regulator takes action which impact in a negative way that investment. So we have a few examples on this slide that I'll go through. For example, changes in the financial regulation may impact the value of a foreigner's investment, particularly when it has an impact relative to other market participants. Restrictions imposed to limit capital transfers or bank withdrawals may prevent a foreign investor from realizing the financial benefit of its investment. In the supervision context, an investor may claim that it is entitled to certain relief from a central bank acting in its supervisory role, or that domestic banks are being treated more favorably than, for example, branches of financial institutions that are licensed in other jurisdictions or that are owned by foreigners. In the financial assistance context, we've seen a number of claims in this area where investors have sought to claim that a bank that's facing a financial crisis is entitled to receive liquidity assistance, or that other domestic banks are being treated more favorably. And we'll come back to these types of claims a little later in the presentation. Bail-ins are also a prime example where we can see an impact on, directly an impact on both shareholders and depositors of financial institutions. Resolution of banks that are either failing or likely to fail may also have an impact on foreign investors. Sovereign debt restructuring, we've had a number of cases involving sovereign debt restructuring. And in that context, to the extent steps are being taken by a central bank to facilitate that restructuring, that too may give rise to investment treaty claims. And then finally, exchange rates and currency control measures may impact the value of a foreigner's investment. So with that background, we thought we would highlight a few specific examples of investment treaty claims that have been brought in this area. The first is René Rose Levy versus the Republic of Peru. This involved claims by a French investor in the Peruvian banking sector based on emergency decrees as well as supervisory and liquidity assistance measures that were related to Banco Nuevo Mundo. The tribunal there rejected the claims on the merits. So in that context, the sovereign prevailed. The next case, Pastova Banca versus the Hellenic Republic. That's a matter that Lori and I handled for Greece. And in that matter, the claimant asserted claims under two different bilateral investment treaties, the Czech Republic Greece bilateral investment treaty and also the Cyprus-Greece bilateral investment treaty, based on steps that were taken by the Hellenic Republic to address its 2012 financial crisis. All the claims in that case were dismissed based on lack of jurisdiction, and the claimant sought to annul that award, but that attempt was also rejected. The next case is a matter that involves mass claims that were asserted against the Republic of Cyprus. There, the claims were based on an adjustment plan that had been agreed between Cyprus and the Troika, that is the European Commission, the ECB, and the IMF, that resulted in the merger of Laiki Bank with Bank of Cyprus and a bail-in. The arbitral tribunal concluded earlier this year that it in fact does have jurisdiction over the claims, and those claims will now proceed to the merits phase. And then finally, there's a reference here to a matter involving the Kingdom of Spain, and Lori and I have been advising the Bank of Spain in connection with that matter, which relates to claims brought by shareholders and bondholders of Banco Popular arising out of the 2017 resolution of that bank, including, again, claims related to requests for emergency liquidity assistance, and that case is pending. So with that background, hopefully that gives some context as to the types of activities that could give rise to claims in this area, and also just to give you some examples of claims that actually have been brought in this area. And with that, I'll turn it over to Lori, who will cover the next topic related to some of the legal standards that apply to the claims and defenses.
Thank you, Chris. Good afternoon, everyone. It's my pleasure to be part of this seminar today. So before diving into the investment treaty standards, I just wanted to take 1 minute for those of you who may be less familiar with how these investment treaties work to explain roughly how these work. They're either bilateral or multilateral. They provide for reciprocal obligations, including substantive obligations, certain protections granted to foreign investors, as well as procedural remedies, such as direct access to arbitration against the host state. And typically they provide for protections of minority and indirect shareholders. So even in countries where the treaty network is smaller, and I know that Indonesia has terminated a number of its investment treaties, investors may still structure the ownership structure of, for example, a bank to benefit from treaty protections. So among the typical treaty protections we see in these investment treaties is the first standard we wanted to discuss, which is the fair and equitable treatment standard that you see on the next slide. This standard is usually, in particular in the older generation treaties, left undefined. It just says that each state shall ensure fair and equitable treatment of the foreign investor's investment. And therefore, it's a facts-based, flexible standard that has been the subject of numerous controversies and different interpretations. Roughly speaking, we've put on the slide the various typical components that most investment treaty tribunals would say form part of that standard. The first one that you see is the protection against the frustration of the foreign investor's legitimate expectations, meaning expectations that were reasonable and on which the investor relied at the time of the making of its investment. Usually they need to be specific, they need to be enforceable, but they often give rise to claims, in particularly in the context of liquidity assistance and emergency liquidity assistance. Moving down to the next prong of claim, the fair and equitable treatment standard is interpreted as protecting the foreign investor against arbitrary or unreasonable measures. So the state will have to show that there is a rational policy behind a certain measures and that the measure at issue is reasonably related to that rational policy. The fair and equitable treatment standard also protects against inconsistent decision making of state organs, meaning different decisions between different state organs, for example, the central bank and the executive, but also could mean inconsistent decision making over time. One day this, the next day something else. Also, what we see among the typical prongs of protection of the fair and equitable treatment standard is the protection against lack of transparency, against violation of due process, acts of bad faith, coercion, harassment, and this last prong that you see is one that financial instrument debt holders, so for example, sovereign debt holders, could rely on and may rely on to argue that a certain sovereign debt restructuring was coercive and therefore in violation of the treaty. And we also see in the list discrimination, but we'll come back to that substandard in a minute. So on the next slide, we wanted to give you a flavor of how these treaty tribunals in these financial crisis case apply the fair and equitable treatment standards. And the good news is that these tribunals would take into account the purpose of the measure and the nature of the measure. And you see here on the slide an excerpt from the tribunal in National Grid versus Argentina, where the tribunal explained that what would be unfair and inequitable in normal circumstances may not be so in a situation of an economic and social crisis. So here the tribunal is taking into account the context of the measure, the crisis. We also see a same type of reasoning in the case of Total versus Argentina case. Again, a case taken following the Argentina crisis. And here you see that the Total tribunal explained that unfairness must be evaluated in respect of the measures challenged, both in light of their objective effects, but also in light of the reasons that led to their adoption. So again, context of the measure is very, very important. And where the measure is taken in an emergency situation, typically tribunals would take that into account. And you see that in the case of the Livy versus Peru case that Chris mentioned earlier, where the tribunal reasoned that it was logical to assume that state authorities would take measures to maintain the stability of the financial system as mandated by Peruvian law, and to that end promulgate some emergency decrees. So this is roughly speaking how tribunals tend to apply the fair and equitable treatment context against the background of a serious financial and economic crisis. Now, moving on to the next standard that is typically invoked by these foreign investors in the financial sector, we see very often claims for expropriation without prompt and adequate compensation, due process, or discrimination. And here it's important to understand that these investment treaties, just like most domestic laws, do not prohibit expropriation, but only prohibit expropriation without adequate compensation and respect for a certain number of legality conditions. And here you see on the slide different types of expropriation as they may be argued by the foreign investor. The first one is what we call direct expropriation. And that's a situation where a state openly and deliberately seizes property, whether by outright seizure or transfer of title. And this is important. The title needs to have been taken away from the investor. That's typically a direct expropriation. But most frequently, the investors would not complain of a direct expropriation. They would complain of what we call an indirect expropriation. And that's where the state measures substantially deprive an investor of the value of its investment without the transfer of title or the seizure of property. And the last item you see on the slide is a form of indirect expropriation or direct expropriation that we often see. It's what we call creeping expropriation. It's where there is a series of measures that over time would result in indirect expropriation. So on the next slide, you see again a number of cases related to the financial and banking sector where expropriation claims were advanced by investors. And again, here you see that tribunals would take into account the nature and the purpose of the measure in determining whether the taking is actually a compensable taking. And that's typically what we call the police power objection. And you see here in the Marfin versus Cyprus case, a case that I think Chris mentioned earlier, the tribunal considers that the economic harm consequent to the non-discriminatory application of generally applicable regulations adopted in order to protect the public welfare do not constitute a compensable taking, provided that the measure was taken in good faith, complied with due process, and was proportionate to the aim sought to be achieved. So here you see context is very much important, and non-discriminatory regulation as such is not sufficient to reach the level of a compensable taking, but there are a number of legality conditions that go around it, in particular good faith, due process, proportionality, and I would add non-discrimination. Another way tribunals can handle this type of claim is to really put forward that states do have a margin of appreciation, particularly during a financial crisis. And here you see again that tribunal explaining to us that the exceptional considerations during a financial crisis may justify the temporary imposition of extraordinary measures that could permit the state to intervene in order to safeguard these interests. And here the important word is exceptional circumstances that would need to be there to justify such measures, and temporary imposition of these extraordinary measures. So it needs to be a temporary framework, and it needs to respond to exceptional circumstances. So on the next slide, we wanted to move on to the third most frequently invoked type of standard and type of claims in these treaty arbitration, and that's claims for discriminatory treatment. So that's where the foreign investor would rely on various protections in the treaty. So we saw earlier fair and equitable treatment standard, but also specific protections regarding non-discrimination. Those may be the protection called national treatment, most favored nation treatment, or a type of clause that reads that the host state shall not impair the investment through unreasonable or discriminatory measures. And here, what is important to understand is what we mean by discrimination, okay? Discrimination is not just differential treatment. Discrimination means that situations that are similar are treated differently. And this is where the Saluka versus Czech Republic holding is very important. The tribunal there explained that state conduct is discriminatory if 1, similar cases are 2, treated differently, and 3, without reasonable justification. So you need these 3 conditions to be able to show a discrimination claim. And some of these treaty tribunals would also require that the measure be targeted specifically against the foreign investor based on its nationality to amount to discrimination. So on the next slide, you see again a series of examples taken in the specific context of the financial and banking sector. So the first case is an interesting case, InvestSmart versus Czech Republic, where an issue of discrimination was raised as to the state aid that was received or actually not received by the bank in which the foreign investor had a stake, as opposed to the other banks in the market. And here you see that the difficulty for foreign investor is to find what we call an appropriate comparator. That is, to be able to show that a bank similarly placed was treated differently. And you see there that the InvestSmart tribunal explained that there must be a broad coincidence of similarities covering a range of factors. The comparators must be similarly placed in the market, and the circumstances of the request for state aid must be similar. And that's where it can get tricky to put forward a discrimination claim. Again, you see the same type of argument being upheld by the Marfin versus Cyprus tribunal. Finally, at the bottom of the slide, you see other types of protections that we wanted to mention, although they frequently appear less, or at least less prominently in these cases. The protections that we call the full protection and security standard, and the protection against imposition or ban on transfer of funds based on the returns of the investment. So with that, what we wanted to move on to is to explain to you the type of defenses that host states may bring up when they're faced with an investment treaty arbitration arising in the financial sector. And you see here on the next slide that we've tried to hit all types of defenses. And the first ones are what we called objection to the tribunal's jurisdiction. So as I explained earlier, how this works is that there is a treaty, so an interstate agreement, that the foreign investor, that is an investor of either state would invoke as to the investments in the other state. And that's where the investor will need to show that it fulfills the requirement for the treaty to apply to it and for the offer to arbitrate the dispute in the treaty to apply to it. And this is where states will have a number of possibilities to object to the tribunal's jurisdiction by, for example, arguing that the investor does not qualify as an investor of the other state pursuant to the definition in the treaty. The state may also argue that there is an objection, what we called here ratione materiae, meaning that the foreign investor does not have a protected investment within the terms of the treaty. And here, let me pause for a minute. It's very important in the context of the financial sector. To give you an example to stress the example that I think Chris mentioned in the context of the Postova versus Greece case, we successfully argued that the tribunal did not have jurisdiction over the dispute between the sovereign debt holders and Greece, because we successfully argued that the sovereign debt instruments did not constitute a protected investment under the treaty. So that's to give you an example of a concrete objection to jurisdiction. There are also the objections to jurisdiction based on the scope of consent in the offer to arbitrate that you find in the treaty. There are also objections based on ratione temporis, based on the temporal application of the treaty. And finally, what we call territorial objection, ratione loci, and that's again an important type of objection in the context of financial instruments, where states may argue that the purchase of sovereign debt on secondary markets after issuance do not constitute an investment in their territory and should not benefit from treaty protection. So once these have been exhausted, and if they're not successful, the state may also look at the text of its treaty and find whether there are certain carve-outs for certain of the measures that the investor complains of. And what we see in modern treaties more often is carve out for prudential stability. So any measures that's taken to safeguard the financial system would be excluded from the scope of protection of the treaty. Then we see if this all fails, there are what we call merits defenses that are typical defenses that we would raise in the context of an arbitration. The first one, lack of attribution, is one that is more often seen in the context of regional organization, where the state has ceded some of its powers to a super-regional organization. But more often what we see in most cases is the lack of causation defense. That's where the host state will argue that the foreign investor's investment was doomed to fail, was actually in such bad financial condition that the bank was going to go in resolution in any event, so that the measures did not cause the harm to the investment. Also, typically, and those we've discussed in the context of our examples, states may raise defenses of sovereign and regulatory police powers. So defenses where the state will argue that it exercised its bona fide regulatory powers in taking such measures and in addressing the crisis. And finally, in the context of discrimination, again, the state may argue that there is no differential treatment because there is no difference in treatment, or because the difference in treatment was justified by difference in situation between the various investors. So if this all fails and the state is found liable under its obligations in the treaty, there's still another line of defense, and that's what we call the customary international law defenses, including the defense in particular of state of necessity. And we've seen that in the context of Greece or Argentina, where these states have argued that the economic crisis amounted to a state of necessity. Most tribunals would consider that this is a possibility, that an economic crisis can amount to a state of necessity, but the conditions to meet the defense are very, very high, and therefore it is very rare for treaty tribunals to apply this defense. Finally, the defense of force majeure is one that states have tried to apply in the context of economic crisis, but so far this has not been successful. So where does this leave us? And that's the next two slides. We wanted to give you a flavor of how these cases turn out on a statistic basis. And we've looked at the public data, and we found about 100 cases related to the financial and public sector. And if you leave out the pending cases and the discontinued or settled cases, you see that in roughly 2/3 of the cases, the state has prevailed over the foreign investor. And that's something that's important because when people talk about treaty arbitration does not always have a good reputation in the sense that it may be seen as biased and pro-investor. In reality, in these statistics, at least in these cases, it is the state that prevails more often than not. But what's important to see, and that you see on the next slide, is that if you look only at the cases where there was an actual award, you see that in most cases, the state prevailed at the jurisdictional phases, right? There are 16 cases in which the state prevailed at the jurisdictional phases, and this is why it's very important to raise the right objection really early on in the process to have the best chance to succeed. Where the state failed with its jurisdictional objection and the case proceeded to the merits, you see that more often than not, the foreign investor prevailed. So it's important to have that in mind, and this is also a reason why Chris will now move on to give you tips and mitigation strategies to avoid these claims being successful. Thank you.
Thanks, Lori. So finally, we wanted to share with you some examples of how central banks might reduce the risk of the types of claims that Lori and I have been discussing so far, including the types of steps that central banks can take potentially to help strengthen their defense against those claims if and when they happen to be asserted. So in the next slide, you'll see that we've highlighted transparency and active communication as being important. And by that, we mean transparency and communication with financial institutions that find themselves in difficult financial situations, because this type of communication is an important counter to potential investment treaty claims. And what an example would be, and the importance of doing this, is to manage the bank and the bank shareholders' expectations. Lori mentioned before that one of the types of claims that often is asserted is a failure to conduct, the state's failure to conduct itself consistent with legitimate expectations of the investor. So it's important from the outset to manage those expectations and not to give investors unreasonable expectations. It's also important to establish a record that the central bank's conduct was well-reasoned and that it wasn't arbitrary. And that's in order to counter due process claims and claims that the state or the central bank acted in an arbitrary fashion with respect to the conduct at issue. So steps that can be taken by central banks to minimize the risk of investment treaty claims include, as we've highlighted on this slide, identifying the relevant legal framework in which the bank operates. And here, what we're referring to is that arbitral tribunals have confirmed that where the host state's conduct conforms with the relevant domestic law, and that domestic law is comparable to the laws of other states, then that is a clear indication that the host state's conduct is not arbitrary. So it's important from the outset for the central bank to clearly identify the legal framework that applies and to ensure that it's acting consistent with that and creating a record that it's doing so. Next, emphasizing central bank discretion. It's important to emphasize to banks that inquire about liquidity assistance, for example, that no credit institution has a vested right to receive that type of assistance, and that whether to grant that type of financial assistance falls solely within the discretion of the central bank. We've seen a number of claims where banks or investors in domestic banks assert essentially that they were entitled to receive liquidity assistance, or that they had a right to receive that. So it's important whenever possible to manage that expectation and to emphasize the discretionary nature of that type of assistance. It's also important for banks to emphasize the posting of sufficient collateral in the same context when seeking to secure financial assistance, and that those assets will likely be subject to considerable haircuts. Again, this goes to managing a financial institution's expectations in the event that it may find itself in need of financial assistance. Next on this slide, communicating lender of last resort principles. I'm sure those are principles that are quite familiar to everyone on this call, but it's important to explain that to financial institutions, that central bank discretion is exercised pursuant to lender of last resort principles, which include the requirement that the bank requesting financial assistance is solvent and that it has sufficient collateral to secure the liquidity assistance that it seeks. And then finally, consider taking proactive steps to prepare banks about the process for seeking to obtain financial assistance. This could include meeting with the bank's representatives to walk them through the internal procedures and steps that would be required before financial assistance could be granted, establishing clear lines of communication so that no communication is overlooked or remains unanswered. And this issue goes again to ensuring that you've created a record that there's been no violation of due process and that decisions are not arbitrary. You can also, as a central bank, consider assigning case teams that would be responsible for monitoring a financial institution that has requested or that may request financial assistance, and again, maintaining contact with that institution in order to ensure that no communications go unanswered. You could also consider training exercises with financial institutions to improve the flow of information when requests are made, and to familiarize those institutions with the relevant procedures so that assistance can be provided quickly if needed. An example here would be in the context of seeking emergency liquidity assistance. Some financial institutions are very familiar with how that process would work, others less so. And it can be advantageous to educate all the financial institutions in this regard, so that in the event they do need that assistance, they know what information is necessary. Their expectations have been managed in that context, and you're able to provide, as a central bank, the assistance as and when it's needed. On the next slide, we focus here on prudence and process. It's important to ensure a fair procedure is followed when addressing requests and inquiries from financial institutions. Of subsequent treaty claims. Avoid communicating publicly about certain issues, particularly specific cases or inquiries from financial institutions about potentially seeking financial assistance. There can be a stigma associated with seeking financial assistance, and markets can react quickly and severely if a request for financial assistance is leaked to the public. Carefully tailor responses to financial assistance requests. Avoid using template documents to the extent possible, because template documents may not respond directly to a specific request. Ensure timely responses. This is something we've already discussed, and it goes to the due process issue that Lori mentioned before. It's important for central banks to avoid a later claim that a financial institution was in dire need of assistance, but that its requests were met with silence. A prompt and reasoned explanation as to why no assistance will be provided is better than no response at all. It's important to document external contacts with financial institutions as well as internal decisions. The main point is to establish a record that decisions are well reasoned, so that if a central bank is the subject of claims later, it's able to rely upon that record to counter a due process claim or a violation of due process claim, or a claim that the bank's conduct was arbitrary. When exercising the central bank's discretion, it's important to identify the relevant factual and legal basis on which that discretion is exercised. And while it's not possible in every instance, if the situation permits, allow the financial institution to comment. Again, this goes to managing expectations and engaging with the financial institution in order to undermine any later claim that a conduct was arbitrary or not well reasoned. And then finally, in the context of a resolution of a financial institution that is failing or likely to fail, it's important to conduct a non-discriminatory and transparent bidding process in order to properly evaluate the fair market price of the financial institutions to be resolved. Again, the main point is it's important not only to ensure that the process is fair, but that a central bank has taken steps to create a record that can establish this fact if there is later a claim asserted by an investor. Next, on the next slide, this is an area that Lori also touched on, which is similar treatment in similar circumstances. And we see a lot of claims asserted in this context in the financial sector by investors claiming that they were treated unfairly. And to prevent against discrimination claims by foreign investors, it's important to establish a record that demonstrates that any differential treatment of the investor or its investment is justified on reasonable grounds. So the first two examples on the slide, the upper right and the bottom, relate to circumstances in which a central bank takes steps related to either a domestic financial institution that has foreign shareholders or is owned by a foreign investor, or a domestic branch of a financial institution that's like. And in either of these circumstances, it's important when exercising discretion with respect to these institutions to explain and document any substantive differences between the bank's domestic comparators or other relevant factors under domestic law. And it's important to establish a record that the treatment of the financial institution at issue is based upon the consistent application of applicable law and also well-established practices. And then finally on this slide we have, it's important during the bidding process for a failing bank that is in resolution. In that context, it's important to ensure that bids received from foreign banks are evaluated on the same terms as bids for similarly situated domestic competitors. And the main point or takeaway for all three of these examples is that it's important to make it clear that decisions are not being taken on the basis of the nationality of the financial institution at issue or its owners, but rather upon the consistent application both of applicable law and also the established practice of the bank. And those may not be necessarily the same. There may be clearly applicable regulations and domestic law on the one hand, but there may also be internal practices that have been established by the bank. And it's important that those practices are also applied consistently, because those internal practices can also serve as the basis for subsequent claims. So with that, this concludes our webinar. We've left a little time at the end to answer any questions that any of you have, and we'd be happy to do that now or at any time later if you'd like to send us an email. But if there are questions, please feel free to use the chat function, and we're happy to field those now.
Thank you, Christopher. Bapak Ibu, apabila mempunyai pertanyaan yang akan ditujukan kepada narasumber kami dari Studi Gottlieb, silakan bisa menggunakan fitur chat atau or Christopher, do you prefer for the participants to raise hands as well?
That's fine too. Whatever, either way is fine.
Okay. Bapak Ibu, you can use the feature raise hand or type your question to the chat. Silakan.
Mbak Rani and Christopher, maybe I will start as a little bit question about this context nowadays about COVID-19 pandemics. Hello, Christopher. As we know, that currently we have a lot of things that going in financial institution, a mix of public health, fiscal, macroprudential, and monetary and market-based policies that actually not in a prudence way, because there is a health and a humanity that we need to consider. Some government lowering governance, bureaucracy that they used to going in the old ways. Now, all people, a lot of governance to that less prudence move. What is your opinion on that matters? What there is in the future regarding the pandemic COVID on the sovereign bonds like that?
Sure. So if I understand your question right, it's the COVID context, for example, the pandemic, will see states and state-owned entities or enterprises taking steps to address that, and will those steps potentially rise to investment treaty claim? And it's a really good question, and it's something that we've been thinking about as well. And there are steps that states have been taking that could give rise to claims. I mean, obviously depends on what types of measures those are, whether they're in the financial sector, whether they're more directed at the public health sector. But there are defenses to those that Lori has already mentioned on the state's behalf. Depends on the investment treaty at issue, but sometimes investment treaties will have carve-outs that will address the type of protected claims. It's really important to focus on the definition of the protected investment in the investment treaty at issue, because that definition may carve out steps that are taken to address public health measures, depending on the investment treaty. So that's one example. You also can potentially have defenses that relate to the police powers type of defense that Lori mentioned before, the need for states to take certain measures in order to protect health and safety and other overriding important issues for the state. But Lori, I'm sure you have a few things to add, because Lori actually spearheaded an article that we wrote on this very issue. So, Lori.
Yes, we drafted what we call alert memo, which you can also find on our website, but we can circulate that concerns health measures and the COVID pandemic and how this would impact treaty claims. And as Chris just said, I mean, it largely depends on the text of your treaty, but what we said earlier plays out here too, which is the context of the measure. So was the measure taken in an acute crisis? That will matter for purposes of the state defense, but also the nature of the measure. Was it proportionate to the goal that was meeting? Was it non-discriminatory? Was it bona fide, or was it for another ulterior motive? And this is where it will be a fact-specific analysis by each tribunal.
Yeah, thank you for the explanation.
Okay, is there any more questions from Bapak Ibu? Please feel free to raise hands or use the chat feature. Christopher or Laurie, can we resume the question after the seminar in case there's someone who wants to ask but feeling hesitate about the speak in the Zoom meeting? So they can ask the question through emails. Is that okay?
Yeah, absolutely. We're happy to follow up with any questions that people have. I see over 70 people have joined, which is really great. And if anyone on the call would rather send us an email as opposed to raising their hand here, we're more than happy to address those questions later.
Okay. Also, can we distribute your material to the participants as well?
Yes, we'll send those to you after this.
Okay, thank you. And maybe it's time for a wrap up from you guys.
Okay, very good. Well, thanks again to everyone for joining. We really appreciate it. It's been very well attended. We appreciate you taking the time out of your busy schedules. And once again, if you have any questions, please don't hesitate to email us separately. Thanks very much.
Yeah, thank you, Ibu, Rani, and thank you, Pak Afik. And as you know, we've worked a lot with your MOF colleagues when we were working on the bond offerings from the Republic of Indonesia, and also some of our BI colleagues. So yeah, thank you for this, for giving us this opportunity to present.
Thank you.
Thanks, everyone. Bye.
Good afternoon, everyone.
Thank you. Should you have any questions regarding this topic of our webinar, please feel free to submit the question through email, and we will forward your questions to our colleague, our speakers today. Thank you once again for joining our webinar. Have a nice day, and wassalamualaikum warahmatullahi wabarakatuh. Stay safe, everyone.
Bye.